Thank you, Jaffer. It's a privilege to be asked to deliver this lecture that honors the memory of Dattatreya Srinivas Borker, a civil servant committed to transparency, constitutional fairness, and public welfare. Recognized as an able administrator of uncompromising integrity, Mr. Borker is credited with many pioneering initiatives, which included advocating urban planning to provide for parks and safe public zones. I am particularly honored that Indira Jaisingh is chairing this lecture. She is an exemplar in the legal profession, having fought and continues to fight for justice for the less privileged, for greater transparency and accountability of our institutions, and in challenging the status quo. She's been a torchbearer for many generations of lawyers trying to find their feet. She continues to be an inspiration for many of us. I'm also very happy that Jaffer is here with us on the stage to introduce the two of us. Let me be permitted to take some liberties with the given title and substitute my vision with a few visions of India of 2047. The past 79 years have told us that there are many imponderables and surprises in store that defy a predictable vision of where we are likely to find ourselves in 20 years from now. In today's lecture, I will first speak on the vision of the Indian legal system for 2047, with a particular focus on the judiciary. Here again, I will speak more about judicial administration, a topic not much discussed, and less on what courts do on the judicial side, a topic that has been much discussed. Thereafter, time permitting, I propose to touch on a few other issues. The broken legal system that we inherited has remained broken. Legal historians have told us that the Anglo-Saxon adversarial judicial system that was introduced sometime in the 18th century quickly became dysfunctional. In response, and after eliciting views of the then magistrates through a questionnaire, Lord Cornwallis promulgated on 3rd December 1790 a scheme that transferred the administration of criminal justice to the hands of the East India Company's English servants. Soon, this new system too failed. The judicial officers were accepting bribes with impunity. Crime was promoted as criminals felt that money could save them from the law. Proceedings in criminal courts were dilatory. Prisons were overcrowded and insanitary. All sounding too familiar, I'm sure. The 19th century was no different. In William Bentinck's time in 1833, it was acknowledged that the criminal justice reforms had failed to achieve the twin objects of a court, cheap and quick decisions of cases. The same scenario played out in 1923 when a civil justice committee was set up for suggesting law reforms. And in 1958, when the first Attorney General for India, M.C. Settleward, chaired the 14th Law Commission, they were faced with the same predicament. They were asked, should we continue with this broken system or go back to our Indian judicial systems? They opted to answer the latter question in the negative, and they said it was enough if we tweaked the current system, despite acknowledging that the primary cause of judicial delays was a host of extraneous and personal factors like an inefficient and inexperienced judiciary, insufficient number of judicial officers, an incompetent and corrupt ministerial and process-serving agency, the diverse delaying tactics adopted by litigants and their lawyers, and the unmethodological arrangement of work by the presiding judge and the heavy file of arrears. Then we have Justice Krishna Iyer in his inimitable style in 1992 telling us that for the lay person, the judicial process was a riddle wrapped in a mystery inside an enigma with its baffling legalese, lottery techniques, habitual somnolence, expensive proclivities, multi-deck inconsistencies, tyranny of technicalities, and interference in everything with a touch of authoritarian incompetence. So here we are after 79 years grappling with the same issues. Too many cases, too few judges, costs, uncertainties, and delays. The problem is complex with moving parts that are imperfectly interlocked. Let me attempt helping you all decipher some of it. To state the obvious, we do not have enough judges. A few statistics require to be noticed, and all of you need to hold your breath. First, the district judiciary. The current pendency in our district courts is over 5.1 crore cases, 80% of which are pending in the criminal courts. Every month, around 29 lakh cases are instituted, and every month, our judges in the district courts dispose of 24 lakh cases. While the sanction strength is around 19,500 judges, at any given point in time, the working strength is only around 18,200 judges, a vacancy of almost 1,300 judges. The per judge load in the district judiciary in our country is a staggering 2,750 cases. Every year, around 2.6 crore cases are freshly instituted, and around 2.4 crore cases are disposed of. There is therefore an unchanging pendency of around 5 crores. Basically, our district judiciary are running hard to stay in the same place. Now to the high courts. The current pendency is 65 lakh cases, of which 45 lakhs are civil cases. The sanction strength is 1,122 judges, but the working strength is only 810, more than 300 vacancies. The per judge load is over 8,000 cases, whereas the Malimat Committee in the 1980s recommended a feasible per judge load for a high court of 1,500. Over 10 lakh cases are instituted annually in our high courts, and an almost equal number is disposed of, meaning that the overall pendency remains the same. Again, high court judges are running hard to stay in the same place. Now to the Supreme Court. The current pendency is 93,000 cases. The sanction strength was only recently raised to 38, and already we have 4 vacancies. The caseload per judge is above 2,400. And as all of you know, ours is the only Supreme Court that does not sit en banc. We have as many as 38 judges now. We have as many as 17 benches. So very often you will have Supreme Court lawyers tell you there are at least 17 Supreme Courts in this country. The caseload of 2,400 is perhaps the highest for any Supreme Court judge anywhere in the world. A Supreme Court judge today is having to read on Mondays and Fridays at least 65 paper books. And you can imagine what a stress it is on both the mind and the heart. In 2025, around 62,000 cases were instituted and nearly 57,000 cases disposed of. And we call this a case clearance rate, which is around 90% across the board. Yes, the collective pendency of cases is the highest for any judiciary in the world. It reminds us of the work that remains to be done. But that is only part of the story. We need to acknowledge that a lot of work is being done by the existing judicial workforce that is clearly overworked. While the Supreme Court manages to have a full complement of judges, we never had a full capacity of judges at any time in the district judiciary and in the high courts in our country's 79-year journey. This is a kind of paradox because judges have to be appointed from amongst lawyers, and we have at present in this country over 20 lakh lawyers. The question naturally is, can we not find among this huge number of lawyers a few who can fill up all the vacancies in all the courts? While the logical answer ought to be in the affirmative, in practical terms, the truth is that we are unable to find enough lawyers who fulfill all the requirements for being appointed as judges. Let me explain this further. In the district judiciary, there are 2 levels of judges: the junior division judges and the senior division judges, who are also known as higher judicial service judges. At the level of the junior division, the recruitment percentage in the recent past has been more than satisfactory. This is owed to a combination of factors: a better crop of law graduates coming through the 5-year law course, looking for a career in the judiciary. The selection process is quite rigorous, written exams followed by interviews. The mushrooming of coaching centers for these exams has certainly helped. Since the starting pay packet for a junior division judge is reasonably good, and there is security of tenure, it has attracted an increasing number of women law graduates. This augurs well for the system as a whole. At the level of the senior division in the district judiciary, there are two broad streams of recruitment. 50% is from among serving junior division judges through promotion, 25% from among them through departmental exams, and the remaining 25% are to be filled up from among lawyers with a minimum of 10 years standing. There are written exams followed by an interview conducted by judges of the High Court. Year after year, and this is what is most surprising, year after year, a large number of these direct recruit vacancies go unfilled. And I must pause here to share with you what Justice Madan Lokur shared with some of us who were his colleagues in the Delhi High Court after coming back from conducting one of these interviews. He looked at the application form of one of these candidates, and one of the columns said, "Please give the names of people you know." So he'd filled up, as the first person he knew, he said, Narendra Modi, Prime Minister of India. So Justice Lokur asked him, you say you know Mr. Modi, but does he know you? He said, sir, but the question simply was, give us the name of the persons you know. So to which Mr. Justice Lokur told him, but at this rate, you could well say President of India. He said, sir, that is what my brother has said in his form, and he's waiting for his interview. This reflects poorly on the competence of lawyers practicing the district judiciary. It also raises serious questions about the quality of the legal education in this country. More on this later. For appointments of judges to the high courts, the procedure is more elaborate, involving the judiciary and the executive. Despite switching over in 1993 to a collegium system that gives primacy to the view of the Chief Justice of India in the matter of appointments, both to the Supreme Court and the high courts, there is a general agreement now that this has not served the objective of getting the best possible candidates. The appointment process has, in the past 12 years, witnessed unexplained interference by the executive. Compounding this is the vagueness of the criteria, a lack of transparency, and an overall inefficiency. Let me explain the last bit. Although we know for certain what the date of retirement of each serving High Court judge is, we are unable to select and keep the replacement ready to take over so that there is no vacancy. A few years ago, at the prodding of the National Case Management System Committee, we simply increased the sanction strength without improving the appointment process. This made the vacancy position even worse. The prospect of never being able to catch up, even by 2047, is real. When Justice Sanjeev Khanna was the Chief Justice of India, the Supreme Court uploaded on its website the criteria that it looks into for selection of candidates for appointments as High Court judges and Supreme Court judges. They called this the performance appraisal template. But that is only a halfway house to transparency. We still need to know whether the candidate found eligible satisfies the criteria. We owe that disclosure to the people of this country. They must have the confidence that only the best among those available are being appointed both to the high courts and the Supreme Court. One dearly wishes this happens much before 2047. At this point, I want to make a distinction between what we commonly understand as pendency of cases in courts. This has been said before, but needs reiteration. The courts cannot be compared to automobile assembly lines, and disposal of cases is not the same thing as assembling cars. It is too simplistic to think that by merely appointing more judges, the existing pendency of cases can be effectively tackled. Every case filed in the system is not a pending case because it has to go through different stages before it can be said to be ready for a final hearing and disposal. Further, each category of case has a different life cycle having regard to its complexity. A murder case cannot be compared to a motor accident or a traffic violation case. There has to be, therefore, a scientific method of first determining what is the optimum time that can be taken for disposing of a particular type of case, and then finding out whether the judge dealing with it has been able to meet that standard. Then there are many cases among the 5.5 crore cases in the formal legal system that are actually dead cases, where the parties are not alive, the subject matter does not exist, the law has changed, the government's position on the issue has changed irreversibly. Then there are absolutely petty and pointless cases, from those punishable with fines for insignificant infractions to enforcement of sureties or an execution petition with the recovery of a sum as low as 1,000 rupees. While I was Chief Justice of Orissa, I found 30 to 40,000 cases under the Forests Act and under the local excise laws, where carrying firewood beyond 5 kgs was a punishable offense. Carrying a plastic can of locally brewed liquor of just 5 liters was a punishable offense. And these standards had been fixed more than 70 years ago, and these cases were clogging up the system. I could persuade the government to say, just increase the limits by twice or thrice, and it ended up closing almost 30,000 cases. So this is possible to be done, but for which we must go into the record rooms of our courts. If these cases are eliminated, we can arrive at a realistic figure of the actual live cases that can be considered arrears if they have crossed